Great, thank you very much. For those who don't know me, I am Tess Hardy. I'm an Associate Professor at the Law School, Director of the Centre for Employment and Labour Relations Law, and it's my great pleasure to introduce the first Labour Law Seminar for 2025. We are delighted to have Professor Guy Davidov join us today, so fantastic that you are in Melbourne. For those who don't know, Guy is the Elias Lieberman Professor of Labour Law at the Hebrew University of Jerusalem. He was the founder and first chair of the Labour Law Research Network, and he was also editor-in-chief for 5 years of the International Journal of Comparative Labour Law and Industrial Relations. His publication list is impressive, it's extensive, and for those who have not yet read his seminal book, A Purposive Approach to Labour Law, I highly recommend that you do so. So Guy will be talking about using AI to mitigate the employee misclassification problem, which is obviously a really live topic in Australia right now, given that there has been so much change around the definition of employment under statute and under the common law in the last 3 years. So I think it's a really timely intervention and presentation. So Guy will speak for about 35 minutes. I'm really hoping we've got time to get your comments and questions, because I think there will be some interesting reflections coming out of Guy's presentation. Before I hand over to Guy, I also just want to thank Claire for helping organise the seminar, and also thank our sponsors. So our sponsoring firms are a big part of how we run the centre and allow us to hold these types of events. So really want to acknowledge their contributions. So over to you, Guy. Thank you.
Really for that. Thank you so much, Tess, for the invitation and introduction. I'm really delighted to be here. I have to be close to that. So I'm going to talk about the paper that was just published as the Modern Law Review, but it's still very much relevant for me to get comments and thoughts about it, because I keep working on the same issue and related issues. And it's about a proposal to use artificial intelligence as a way to mitigate the employee misclassification problem. And I imagine you're all labor lawyers, or most of you, so I'm sure you're familiar with the problem of employee misclassification, which is an eternal problem of labor law. There's always a situation of at least some employers who try to misclassify employees as independent contractors because they want to secure the gains of employment for having someone who will actually be at your disposal to do whatever you tell them to do, but at the same time, avoid paying the direct cost of all the labor legislation, minimum wage, working hours, whatever, vacation, or anything else that you don't have to pay to independent contractors, and also the indirect cost resulting for some inflexibility, the fact that you can dismiss someone without reasons, perhaps, depending on the country, etc. And I think that this well-known problem of employee misclassification, which is persistent throughout the world, is made possible, I think we can say, by a combination of the indeterminacy of the law together with the difficulties of enforcement. And I want to talk a little bit about them. Employee status is decided basically all over the world by multi-factor tests, which are inherently indeterminate. So if you look holistically at several indicators and decide together if someone is an employee or not, there's an opening there, standard rather than a rule, open-ended standard, there's an opening there for discretion, and that's indeterminate by nature. There are some attempts to make the test less indeterminate. So for example, many of you maybe are familiar with the ABC, the relatively new ABC tests in California, which has a strong presumption of employee status, and in order to rebut the presumption, the employer has to prove A, B, and C, so there are 3 conditions that you have to prove. It's a little bit less indeterminate, but still each one of the A, B, and C factors has some open-ended nature. So one of the A is something like control, basically. So whether there is control, you have to look at several indicators. So again, there's at least some degree of multi-factor nature, I guess. So I think to improve this, and I think the ABC test is a good development. I have an article where I suggest some variation of it, or try to support some variation of it. And overall, the whole project of trying to improve the test is important. I invested a lot of my time during my career in trying to suggest new and better tests, and I think it is important and worthwhile, but it doesn't do much to curtail specification. So I think the main idea of better tests for one as an employee is to actually capture the right group, the people, all the people who need labor law and exclude the people who don't need labor law. But it doesn't help you to ensure that employers are not evading it. And for that we need something else. And that ties with the enforcement problem. So employee specification is just one manifestation of a more general problem of enforcement. And I think the challenge of enforcement is increasingly seen in the world as a central problem of labor law. And of course, there are some people here, Tess and John, especially who work a lot on this topic. And not talking, of course, about Australia, which I don't know enough about, but in general, in most of the countries, state enforcement is notoriously lacking. And I think because of lack of resources or other reasons, and I think it especially struggles state enforcement with misclassification as opposed to, let's say, a minimum wage violation or working time violation. Because with misclassification, these are people who are not even reported to the state as employees. You have to somehow find them to realize that they are employees, even though they are reported as, they're not reported anywhere. They're independent contractors, they're considered by the employer as independent contractors, in order to even start understanding that they might be violations here. So it's more difficult to reach. It's not impossible, of course, but I think enforcement mechanisms of the state struggle, especially in this context. Then there's, of course, self-enforcement. So at the end of the day, in most countries, we mostly rely on self-enforcement on people actually, workers actually suing to get their rights, but it faces significant barriers, just to name a few. A lot of people don't know enough about the law, they don't realize that they have been misclassified or there are other violations. Even if they do know or suspect there might be a problem, they often lack the resources to get legal advice, to sue. And finally, a lot of people fear of some litigation by the employer or having a troublemaker reputation. If it shows up on Google afterwards that you sued the previous employer, it doesn't look good when you look for other employment. So self-employment is also highly problematic. Now, of course, this is a very simplistic introduction to the problem of enforcement, and there are all kinds of new enforcement tools, and I know that here in Australia you have experimented with some new ideas, and there are additional proposals in the academic literatures, and these are all important, but I don't think they are significantly able, at least so far, to curtail misclassification. So I think we need a special solution, enforcement solution for misclassification that goes beyond existing attempts. And I think the solution has to come from realizing the root cause of the problem. And I want to suggest a way to articulate or describe the root cause of the problem. I think that because of the indeterminacy of the law, which I just described, together with the general enforcement difficulty, together with the inequality of bargaining power in the background, what we have is de facto power of the employer to unilaterally set the default legal status. And by the term default legal status, I mean the status that applies until a court rules otherwise. In theory, the employee can go to court and say, well, this status of independent contractor, which was imposed on me by the employer, is not real. I'm actually an employee, you can do that. But most people don't do that. Okay? And so in practice, de facto, the employer has this power to actually set, it's just the default in a sense, because you can go to court and try to change it, but until you did that, which most people don't do, the employer has the power because of these factors to set the status unilaterally. So even though in theory employee status is of course non-waivable, you can't waive the employee status, in practice it is often waived. So I think that to solve this problem, we have to change the default. by saying that a worker should be treated as an employee, as a default, not let the employer decide what is the default and decide if they want to get you an independent contractor, but force employers to treat you as an employee unless the employer receives specific authorization otherwise. Now you might think that this is totally unrealistic, and that's what I thought until AI opened my eyes to this possibility of doing something with it in this context. Because getting pre-authorization from a government agency for every engagement with an independent contractor certainly seems unrealistic. There's thousands of these contracts every day of engagement with independent contractors. But what if this authorization, pre-authorization, can be given by an algorithm, by using predictive AI? Automatically, you just fill a form online, and within 5 minutes or a couple of minutes, you get the authorization or deny the authorization if the computer thinks, the algorithm thinks that this is actually an employee. That seems more realistic, I think, and I think it's now made possible because of the advancement in AI, and relying here for the empirical basis on a paper by a group of scholars from Queen's University in Canada, Cohen and others. One of the others is Samuel Dahan, he's the labor lawyer over there. And they actually tried this and achieved over 90% accuracy with the algorithm, with the program that they created, identifying employee status. And after taking out cases with missing information, even 96%, which is very, I imagine, at least as high as human lawyers. You never get 100%, of course. Now, their program is pretty primitive, pretty basic in terms of AI. So it's not like the newest, it's before ChatGPT. It's a little bit before it took time to publish it. So I imagine that it only gets better all the time. Now with all the rapid developments in the last couple of years, it's probably can get better. I have to say that there are some studies about the predictive abilities of AI to predict the law in other areas of law are much less positive. They have shown much less success. But I think from what I read about these studies, this is mostly when you try to get from AI a very complicated legal question, very complicated in terms of not only facts, but the number of legal issues. Again, these studies also predate the recent developments. I don't know what's going on today. But I think the results of Cohen and others are consistent with other studies. When we focus on studies about specific questions, like here, that have a binary result. So it's either an employer or an independent contractor. You're not asking the computer to give me a general assessment of what are the legal risks in this situation. I'm just asking you a simple question of yes or no. Is this an employer or not? And it's also a fact-intensive question of law. So because it relies on a lot of facts that you have to enter the facts into the system, other questions have been tried in that respect. I also showed good results. So I think it's fair to assume that the proposal I'm suggesting here is possible. And it's not so futuristic, it's totally possible. And I think everyone who played a little bit with ChatGPT will not be too surprised about it. It's not that complicated. If the system has all the cases, the data of all the cases, just like lawyers can do it, an algorithm can do it, an AI can do it. So what do we do with this technology? We have this technology that can predict if someone is an employee or not. One thing that is possible is to let lawyers buy this system or get this system and somehow use it to save time when they advise their clients. This is, I guess, the most minimal one. We can also actually provide it to workers directly to be able to check by themselves what is the status. This group in Queen's University in Canada, that's what they did. They actually put it online free for workers to use, but not many people use it. Because of what I said before, the fact that people don't even realize, that they might have a problem here legally. So not enough people use it. And at the other extreme, we can actually say, there are some proposals for robot judges, automatic decision making to replace courts altogether, just let the machine make the final decision. I'm not suggesting that. What I'm proposing is somewhere in between, not just legal aid, not just use it to allow people to, find out what the legal situation is. I want to give it some normative force, but at the same time, not to replace court. So my proposal would be somewhere in between, and I'm going to explain the proposal here. So I'm suggesting an automated system powered by AI that will be operated by the state. Right? So it's an official system that needs legislation. And employers will be required by the legislation to request pre-authorization for engaging with someone as an independent contractor. The employer will have to enter the facts. I can talk about it later in the discussion if you'd like. I realize it's not ideal if you let the employer enter the facts, but I think it's the best solution. But it will have to answer specific questions. So there will be a list of specific questions. In theory, AI can be used to develop the list of questions and change the list of questions, but it can also be done by humans, based on the case law. But at the end of the day, the input of data will be based on a list of questions that require a specific answer, and then you receive an immediate decision from the system. If you are denied, so you're asking for a authorization to engage with someone as a contractor. If you are denied, the employer should be able to appeal. So as I said, I don't want to let the computer make the final decision, but you can appeal before a court, or if the state wants a faster process, you can always create a faster process. For example, a quick appeal before a human governmental agency. If you receive the authorization, then you can start the engagement. The worker will also receive a copy of this decision, together with the facts that the employer reported to the system. So, at any time, the worker will be able to request a reassessment, that's my proposal, based on corrected facts. So let's say you saw that the employer reported some specific facts, but you're saying that's not actually true. They probably reported it to get the authorization, but that's not reflective of the reality of the relationship. Then you're always free to go to the system and ask for a reassessment, and then if they rule out that you're an employee, then they will have to treat you as an employee. At the end of the day, that's an important part of the proposal. The worker can still sue for employee status with the regular courts or tribunal, depending on the country, at any time. So the final decision should remain with the courts. I was asked by a few people who read the paper or previous presentations, why is this different from a presumption? Because in a growing number of systems, there's a presumption of employee status, and the strongest version is the ABC test in California, which I mentioned before. There's a presumption that you're an employee, and in order to rebut the presumption, the employer has to prove A, B, and C. The three conditions over there. It is different, significantly, because the presumption only becomes relevant if a case gets to court. If a case gets to court and it's a 50-50 and a close call, then the presumption, you rule in favor of the employee because there are presumption. Now, of course, the fact that there is a presumption might influence the decision of the employer before it's getting to court. They might say, okay, if it's a close call, I will lose. But it doesn't change much the incentives of the employer if they know that a large majority of the cases do not get to court. So what are the chances that it will get to court and the court will see it as a close call? Not that high. In that sense, it doesn't make much difference on the root cause, what I call it. The fact that the employer is able to unilaterally set the default legal status. Another way to say it, the employer is legally allowed to treat someone, if there is a presumption, you are legally allowed to treat someone as an independent contractor, of course. You just have to say that if it gets to court, I can prove that this is an independent contractor. I can rebut the presumption. It's totally allowed to do that. If you require pre-authorization, not anymore. You're not allowed to treat someone as an independent contractor legally unless you get the authorization from the system. So that's a big difference. What's the expected impact? think most importantly, I'm proposing a new procedural rule. Because it's a procedural rule, and it's a very simple rule, you need to get pre-authorization. It's relatively easy to enforce. And I think that violation should lead to significant penalties. I think this can be expected to minimize misclassification dramatically. There are, in terms of the compliance and enforcement literature, I think it's useful to refer to the book by Yuval Feldman from 1918, The Law of Good People. It talks about three types of employers, not employers, people who violate the law. But in our context, it's employers who misclassify. Okay, it talks more generally about people who violate the law. And the first group, erroneous wrongdoers, these are people, the employers who didn't really realize that they break the law. It will be helpful for them to have a simple procedural rule that is more publicly known. You need pre-authorization for the system. So before you knew that it's possible to maybe to hire someone as an employee or an independent contractor, but you weren't sure, you didn't really realize the details. Now we have a simple rule. I need to go to the system, to the website, to get authorization. I think we'll see less violations from them. Second group, situational wrongdoers. These are people, and the literature that is relevant to them is all the literature on behavioral ethics, who kind of cheat themselves, rationalize it to themselves, to think that what they're doing is okay, even though they realize it's a little bit iffy. Or they realize that they might violate the law, but I'm trying to rationalize it to myself or convince myself that it's not really the case, or not that bad, or not immoral. These people rely in their minds on the wiggle room, some wiggle room to make this, to think for themselves, it's okay to do it probably. We have less wiggle room with a clear procedural rule. Okay? It's not that multi-factor open-ended that I can use to convince myself it's fine. No, I have to follow this procedural rule and get the authorization. And finally, the last group is calculated wrongdoers. These are people who don't care about violating the law. They just do a cost-benefit analysis. If it's more beneficial for me to hire someone as an independent to misclassify, that's what I'll do. So for them, I think there will be more significant costs for breaking, because again, it will be easier to enforce the procedural rules. So now, in most cases, we just don't get to them. If we get to them more frequently and for this procedural violation, I think the calculation, the cost-benefit analysis might change a little bit. So basically, what I'm saying is that for all three types of violators, this rule can be helpful in improving the situation. I do acknowledge that there will be some administrative burden. I think it's very minimal. The fact that you have to go to a website and get an approval, authorization, that's for authorization. It's not a big administrative burden. I think the main cost is when the system gets it wrong. So what if you were supposed to get the authorization? It actually looks like an independent contractor, but somehow didn't get it. So first of all, as I said, I think the mistakes are going to be relatively rare because the system can have a high rate of accuracy. Also, an employer has other ways to mitigate potential inefficiencies, so it's not the end of the world if I don't get the authorization. I can appeal. It is costly maybe, so I can take someone else as an independent contractor with different characteristics. Or maybe I can employ that person as an employee, even if that's what wasn't my first preference. At the end of the day, you have several options to choose from that somehow reduce the cost, but even acknowledging that there is going to be some cost. I would argue that some cost is justified because what we have now in most countries is a reality of common misclassifications. And this has harsh implications for workers who are misclassified. These are the most vulnerable workers usually who are misclassified. They don't get any rights that they should get as employees. And also there are implications for society at large. It has often tax implication, but also their families are affected if they don't get vacation, if they're not working hour violation, etc. So I think that given that reality, some cost is justified. Of course, there are some difficulties with the idea of relying on AI to have this normative force. And I want to break the difficulties into two. First of all, the fact that we rely on probabilities, and then I'll separately talk about the fact that it's AI. So first, the fact that it's probabilities. AI systems rely on data of previous case law to predict the law in the new case. And this prediction, of course, estimates the probability of the result. This is the same problem if we give a human agency, let's say labor lawyers at the government, the task of giving pre-authorization. They will also make a prediction. It will not be 100% correct. So that's why I'm separating it from AI. And the problem in that case is that, let's say there's 80% chance, the lawyer predicts there's 80% chance that you are an independent contractor. It means that, out of 100 cases, in 20 cases, it will probably be the other result. In 80 cases, it will be this result. That's the 80% chance. If you set the law based on the 80%, I'm saying 80% chance you're an independent contractor. In all the similar cases, I will decide you're an independent contractor. In a sense, we're changing the law in that sense from being relying on 80% to make it 100%. Okay? So that sounds like a problem, especially if it's closer to 51%. If all the cases that shows 51% of independent contractor, we'll treat them all as independent contractor, even though almost half of them should have been treated differently. Seems like a problem, but I think we should remember that according to the proposal, the AI system will not be used to set the actual law, but just the default applying until a court rules otherwise. You can also always get this to the court and get a contradictory decision. So I'm not ignoring, of course, the fact that it will have normative force, because most cases will not go to court. But I think overall the advantages outweigh the problem here. Once you remember that, if you insist that you are part of the 20% or whatever, 49%, you can always go to court and get a different decision. Now about the fact that we rely on AI. There are four main challenges. I'll do it quickly to leave time for discussion based on the literature dealing with similar issues. I want to talk about four main challenges with relying on AI for this purpose. Yeah. First one is the fact that the prediction are based on previous case law means that in some sense the predictions are backward looking. So we're just looking backward at previous cases and base our decisions on that. And the worry that is raised is, will they be able to deal with new employment formats? So for example, platform work, a new format like Uber drivers. The system doesn't have any single example. So people can say, well, it will fail when trying to assess, to predict the law with regard to this new format. So I have a few answers for that. First of all, as I suggested that there will be a list of questions. The list of questions based on previous case law, but arguably, I think, the questions that are relevant for the decision are still the same, also for platform work. So the same questions, we're not looking for specific facts, we're looking for specific questions that are important. Just to give an example, if we're looking for factors suggesting subordination or control, it could still be relevant for platform work. The control may manifest itself in a different way. But I think that in most cases, the same question should lead to the facts that are relevant to the determination. On top of that, what happens if the system fails in dealing with new formats? So it can fail in two directions. One way to fail is if the system wrongly concludes that someone is an independent contractor. Let's say they concluded the Uber driver is a contractor. Actually, they should have understood, if they understood it more deeply, that they are employees. In these kind of mistakes, we are in the same situation as today. What we have today is that, if Uber misclassifies you as an independent contractor, you want to challenge that, it's the burden on you, the the misclassified employee to take it home. It will be the same. So it might not improve the situation for new formats, but it will not worsen the situation either. If the mistake is on the other way, if the system wrongly concludes that someone is an employee, then, as I said, the employer can appeal. It's possible also to make a fast process for appeal, a cheaper process, and anyway, I've argued that the harm is not that excessive for employers. Second problem, also related to the fact that it's kind of backward-looking when we rely on data that is in the system, is the worry that it will lead to stagnation of the law. Because we'll definitely need some cases to reach the courts in order to allow judges to develop the law in light of new realities, new values, new ideas. And I think it's true that the number of cases about employee misclassification is expected to drop dramatically. But I think this is mostly because there will be less misclassification, thanks to the new procedural rule. And also because workers will better understand their chances. Because I remember you get from the system a letter as the worker, an email saying the employer was granted the authorization to treat you as an independent contractor based on an assessment of that you are 80% or 90% an independent contractor based on the following facts. So as the worker, you can see if the facts were reported correctly, and assuming so, if they are 90%, I won't take it to court, probably rightly so. Will save you the money, because you're going to lose anyway most chances. I think that new work formats, like platform work, etc., but also borderline cases, if they tell you, okay, if they got the authorization because there's 51% that you're an independent contractor, these borderline cases and new formats will still lead to court challenges. It will still be an incentive for employees, misclassified employees, to take these cases to court, and I think that should be enough room, enough cases to allow the courts to develop the law. Third challenge of AI is what's called in the literature automation bias. The fact that judges might defer to what the automatic system say. Will they have enough confidence to overrule the assessment of the law made by AI? So without ignoring the fact that this is a general problem, I think that in the specific context it is not that great. The problem is not that great for a couple of reasons. First of all, this is a question that requires judicial discretion and also involves some policy consideration, and I think the judges will see themselves as the experts on these types of questions. Also, this is a decision that relies heavily on the facts. Now, the AI system based its decision on the facts that were reported by the employer, and they were reported by the employer a while ago when we just started the employer. Now, when the case gets to litigation, maybe the facts have changed over time, or also maybe after litigation, you realize as the court that it's not exactly how the employer suggested it. So I imagine that because it's different sets of facts, judges will realize that the AI prediction is no longer relevant. Finally, I also think that the legislation should explicitly direct the judges to ignore the AI prediction. That might also help a little bit. Last point about a possible challenge and a reply to it with the reliance on AI. There is, of course, a transparency issue with AI. Because complex AI systems are often impossible to understand. It's a kind of a black box. So decisions are also hard to explain, and that creates a problem of legitimacy. I think that in the particular context, the proposed system is quite simple. And it can also deliver reasons. So for every fact that we asked you to report and you reported, the system can say this leads to the direction of independent contractor or employee in each side, and then at the end it will say overall, after we're looking at all the facts, this is the decision with 70% probability or an employee or independent contractor or whatever. So it's possible to give some reasons for the decision. What it's not possible to do, or I think shouldn't be done, is giving an exact formula. The exact weight given to each fact, to each factor, will remain opaque. But that is actually the same with judicial decisions about Versailles. So we know, the parties know that these are the relevant factors, and the court in the reasoning says that, okay, this factor leads in that direction, this factor leads in that direction, but then the overall formula of where did I give more weight is never explicitly stated, so I think it will not be very different from a court decision on the matter in terms of transparency. So, to conclude, this classification is an age-old problem of labor law, and I think that the most effective way to address it is by changing the default legal status, not letting the employer decide unilaterally. I think that with the new technological capabilities, it's now possible to address it by requiring this pre-authorization. Of course, it requires political will, it requires new legislation, so this is of course always a challenge, but at least I'm proposing it as a shelf solution in a way, if there is political will to accept it. Thanks.
Thanks, Guy.